Ladies and gentlemen, good morning to all of you. Welcome to the plenary session, the first of the day today. There are some more seats down in the front for those who are standing in the back if you wish to come down. My name is Dave Campbell. I'm a federal judge from Arizona in the United States, and I have the privilege of moderating a panel this morning consisting of some very distinguished judges from around the world. We have about 20 judges with us at this symposium, and I wish all 20 could be up here to speak because they are all impressive and wonderful people. We will have breakout sessions for the judges that will continue the discussion that we are starting in this plenary session this morning, and I will be introducing these judges to you in just a moment. I do want to mention at the beginning something that I'm sure you're aware of, which is that judges are not politicians, despite what some that. And I'm sure you'll understand that's because of the position they are in and the neutrality that they need to maintain. The topic that we are going to be discussing in this plenary is the importance of the rule of law and independent judiciaries in protecting and promoting human rights around the world. So even though the focus of this symposium is religious freedom and human rights, we're going to start with a discussion of the rule of law. And that's appropriate since we're focusing in this symposium on the 75th anniversary of the Universal Declaration of Human Rights. It's an unusual document in that it not only sets forth human rights, but it also talks about the rule of law and the role of courts in protecting those human rights. In the preamble to the Universal Declaration, third paragraph, it says, quote, "It is essential that human rights should be protected by the rule of law," close quote. And Articles 6 through 12 of the Declaration set forth characteristics that the rule of law and courts should have if the human rights set forth in the Declaration are going protection against arbitrary government action, to an independent and impartial tribunal or court, to fair judicial procedures, and to protections against attacks on privacy, family, and home. Those are all contained directly in the Universal Declaration. As we all recognize, even an impressive list. This is my mic. I'll use both mics. Is that better? Okay, good. Thank you. Even an impressive list of human rights contained in a constitution or a statute is meaningless if the government doesn't honor those rights and the courts enforce those rights. Because we're going to be talking about the rule of law, I would like to start with a brief definition of the rule of law, and my colleagues will add thoughts to this. Here is one definition of the rule of law. The rule of law is a principle under which all persons, institutions, and entities, public and private, including the government itself, are accountable to laws that are publicly promulgated, equally enforced, independently adjudicated, and consistent with international human rights principles. That's a definition that was issued by the U.S. State Department in 2010 and is similar to other definitions from around the world. One of the things mentioned in that definition is independent determinations, independent courts. As we all recognize, it is sadly often the case that it is the government that either fails to protect or restricts human rights. So if courts are going to enforce those human rights, they must be independent of the government and not under its control, because from time to time they have to rule against the government and rule that the government has violated human rights. This is a very timely topic for all of us in the world today, because human rights are critical around the world, and the rule of law is in decline in many parts of the world. The World Justice Project each year produces a report that evaluates the rule of law in 140 countries around the world, considering 44 different factors and collecting information from citizens of those 140 countries. The World Justice Project has found that between 2015 and last year, the end of 2022, nearly 65% of countries in the world showed a decline in the rule of law. That means that 4.4 billion people, 56% of the Earth's population, live in countries where the rule of law has weakened in the last decade. And of course, where the rule of law declines, human rights decline. So our panel is going to help address this subject for us. I'm going to introduce them briefly. They have fuller biographies in the materials that they have received, but let me describe some of their accomplishments. To my immediate left is Judge Armen Harutyunyan. He is a judge on the European Court of Human Rights. He is the Armenian judge on that court. You may know that court represents 46 countries and has one judge from each country. And he is from Armenia. He received a diploma in law from Armenia's Yerevan State University Law Department. He has received his PhD and doctorate in laws from the Russian Federation. He also graduated from the Human Rights Law Center at the School of Law at the University of Nottingham. He is a professor of constitutional and international law and has held numerous positions in the area of human rights that are set out in the materials. Next to him is Justice Ioannis Ktisakis. He is also on the European Court of Human Rights. He is the Greek judge on that court. He taught before he became a judge on the court at universities in Greece and Turkey. He was also a visiting professor of law at George Washington University Law School here in the United States. He formerly served on the executive board of the European Union Monitoring Center on Racism and Xenophobia and on other human rights bodies, and he is widely published. Next to him is Justice Helen Ogunwumiju. I've been practicing that. She is a justice on the Supreme Court of Nigeria. She graduated from the University of Lagos and was called to the Nigerian bar in 1978. She worked with the Legal Aid Council for many years. She has served in just about every judicial position in Nigeria, as far as I can tell, as she has worked her way up to the Supreme Court, including being a judge on the High Court for 7 years and on the Court of Appeals for 15 years before being elevated to the Supreme Court. She has served as president of the National Association of Women Judges in Nigeria and as a member of the International Association of Women Judges. And she is the chairperson of the Board of Trustees for the West African Regional Center for Law and Religion Studies, as well as chair of the West African Judicial Expert Group on Law and Religion. Next to her is Justice Jose Reyes from the Philippines. He's actually retired now from the Philippine Supreme Court, where he served. He earned political science degrees from colleges in the Philippines. He was the presiding judge of the Metropolitan Trial Court, presiding judge of the Regional Trial Court, an associate justice on the Court of Appeals, and chairman of the Appellate Court's 4th Division. He is a professor in the College of Business and Economics and also a treasured professor in the Department of the Philippine Judicial Academy. He is also an active Eucharistic minister of Villa San Miguel Chapel in the Philippines. And at the end, last but not least, is Justice Engin Yildirim. He is a justice on the Constitutional Court of Turkey. He served as vice president of that court for several years. Before his appointment to the court, he was a law professor at the University of Sakarya. He holds a PhD in sociology from the University of Manchester, and his research has appeared in numerous academic journals. What we've asked the judges to do to begin today's discussion is to have them each take a few minutes and describe the courts in which they serve, how those courts encounter human rights issues, and other thoughts they may have. We're going to just go down the line and hear from each of them, and then we're going to follow with a panel discussion where I have some questions that I will put to them. We will leave time at the end for you to ask them questions.
This is a great honor for me to be here and to present European Court of Human Rights, a very unique organization which is only international and regional institution which judgments and decisions are legally binding for 46 member states. I will present you in 5 minutes. I was asked to be short the role of our court in regard to promotion and protection of human rights. And after, if you have questions, of course, I am at your disposal. So, dear colleagues, first of all, I have to say that the European Court of Human Rights design, let me say, European human rights public order among 46 Council of Europe member states. How our court is doing that? First of all, our court is establishing that system of values, democracy and rule of law, and each member state will join to us. They have to know that democracy and rule of law are obligatory and binding system. I will read in United Communist Party of Turkey and Others versus Turkey, 1998, a court wrote, democracy thus appears to be the only political model contemplated by the Convention and accordingly the only one compatible with it. It means that if countries want to become a part of Convention, they have to establish democracy and rule of law, because without democracy there is no possibility to protect and promote human rights. Why? The other things which I would like to present you, this is a principles based on which our court is working, and one of these principles is a subsidiarity principle, which means that we are not a first instance court, and primary role in regard to protection and promotion of human rights belong to national institutions. So that is why before coming to our court, applicants, they have to exhaust domestic remedies. But it means, and it is reflected in our Convention Article 13, that member states, they have to create effective remedies, because if domestic remedies must be exhausted before coming to our court, these remedies must be effective ones. So this imposes obligation on member states. And the second one, only effective remedies are in the position to ensure social balance in the societies. And in Ceramic versus Austria, yet in 1984, court underlined that court must inspire confidence in a democratic society. So principles and values on the one hand. On the other hand, our court, based on its case law, is designing a roadmap for member states in order to help national institutions to understand in which way they have to examine, they have to structure their courts, and knowing from which point of view we will be examining the cases which we are accepting. First of all, by roadmap, I mean that courts does have one methodology which, and should be a methodology of member states. We have our examination based on 3 elements. So whether intervention into the rights, where described by law, whether this intervention was pursuing legitimate aim, and whether that intervention into the rights were necessary in democratic society. This is one methodology which should be methodology of our court and national institutions. The other thing that in each case, court is trying to establish, to present tests which will be roadmap in some ways for national institutions to understand in which direction they have to go. For example, we are talking about independent of judiciary, independent court. So from this point of view, yet in 1994, in case Campbell and Fell versus United Kingdom, court has presented its test, which is obligatory for national institutions, and they have to be based on this. The test regarding the independence of tribunals consists of 4 elements: the manner of appointment of its members, the duration of their term of office, the existence of guarantees against outside pressure, and whether the body presents an appearance of independence. These 4 elements we will examine in order to understand whether we are dealing in the case with independent and established by law tribunals. The other thing that in Europe, very often in regard of dismissing and sanctioning judges, there are special bodies. So in general, we can call them high justice councils. And very often we are facing in this or that country dismissing of judges. And in one of our cases, court present a test based on which court will accept the position of member state if that Council of Justice coincides with these institutions. And in Volkov versus Ukraine in 2011 by Grand Chamber, court underlined that court found that the composition of the High Council of Justice as provided for by the Constitution had disclosed a number of structural shortcomings, which are the following. First, the majority of High Council of Justice had consisted of non-judicial staff appointed directly by the executive and legislative authorities. Among the 16 members of this council who had attended the hearing of the applicant, only 3 were judges. The vast majority of High Council of Justice members worked and received salary outside of that organizations. And Prosecutor General was a member of High Council of Justice. And the members of High Council of Justice who had carried out the preliminary inquiries in the applicant's case and submitted requests for his dismissal had subsequently taken part in the decision to remove him from the applicant. So, court designed the test based on which this Council of Justice should be based in order court recognize them as independent tribunals established by law. And all this court is doing in order to facilitate establishing independent courts and Council of Justice in the member states. The other very important thing is a fair trial, because European Court of Human Rights is a quasi-constitutional court of European countries, and we are distinguishing institution and function. Why we need independent court? In order to provide fair trial. And in regard of fair, because without independent court, without democracy, without rule of law, there is no fair trial. And court, in one of its cases, underlined, the court has always emphasized the prominent place held in democratic society by the right to fair trial. Stanev versus Bulgaria, 2012, Grand Chamber. The guarantee is one of the fundamental principles of any democratic society within the meaning of the convention, Mamaladze versus Georgia, 2022. The judge offers legal protection in disputes between citizens and the government and between citizens themselves, thereby helping to ensure fair and just societies and limiting abuse by governments and state authorities. The right to fair hearings must be interpreted in the light of the preamble of the Convention, which declares, among other things, the rule of law to be part of the common heritage of the contracting states. arbitrariness entails a negation of the rule of law and cannot be tolerated in respect of procedural rights any more than in respect of substantive rights. And court continues, the judiciary's fundamental role in a democracy is to guarantee the very existence of the rule of law and thus to ensure the proper application of the law in an impartial, just, fair, and efficient manner. And last, in order to be within 4 or 5 minutes, so in case of Persak versus Belgium, court and underlined and gave test what kind of internal structures must be within the national institutions. So, as you see, court is leaving the primary role to national institutions, but together with this is ensuring and presenting system of values and a roadmap for national institutions to design their courts, their tribunals, in order to have effective remedy, and only after that it will make sense that applicants have to exhaust domestic remedies before coming to our court. So these are ways how court, as I said, design European public order in regard to human rights. Thank you.
Thank you.
Good morning. I want to thank the organizers for this very honorable invitation here to Provo. Two brief observations before explain what is the position of rule of law in our case law in the European Court of Human Rights. First point is that the European Convention of Human Rights has been adopted in the context of international organization, a regional international organization, the one of Council of Europe in 1950. And under the statute of Council of Europe, there are 3 pillars for cooperation of the 46 member states. The first pillar is democracy, the second human rights, and the third rule of law. Then the rule of law is also mentioned to the preamble of the European Convention of Human Rights, like it is the case also in Universal Declaration of Human Rights. My second preliminary point is about anniversaries. Yesterday, Brett Scraft referred to 3 anniversaries. First, of the Universal Declaration of Human Rights. Second, of the 50 years of this law faculty of Brigham Young faculty. And the third is about the 30 years of this annual conference on law and religion. There is a 4th one which we celebrate this year in Strasbourg, where the European Court of Human Rights is based. And this year marked the 30 years since the European Court delivered judgment in the case Ktisakis versus Greece, the first ever judgment on the basis of freedom of religion under Article 9 of the European Convention of Human Rights. This landmark judgment is, if I'm not wrong, referred to all the manuals about freedom of religion. And the case was about a Jehovah's Witness believer, the applicant, who has been condemned by the Greek authorities for the crime at the time of proselytism, and the victim was an Orthodox believer in Greece. We are very proud about this judgment in Strasbourg, and since 1993, all the following judgment about freedom of religion of the court refer to this landmark judgment. Then, in our case law, the rule of law has a normative force. And this normative force is expressed under 3 dimensions: the organic dimension, the functional dimension, and the hybrid dimension. In the first case, As a legal principle in its organic dimension, the rule of law acts as an optimization requirement, preventing member states to the European Convention from restricting the rights and freedoms protected by the Convention, including freedom of religion, either arbitrarily or in such a way as to deny the very essence of the right in question. The rule of law, therefore, in our case law, imposes strict substantive requirements on the content, quality, and temporal application of the national legal basis invoked by the defendant state to restrict conventional rights. Procedurally, the rule of law requires that the final judgment on the content of the law be taken not by those in power, but by independent judges. In the second case, the functional dimension, the rule of law involves a rule with a fairly fixed content, which includes a specific functional element of the rule of law. It is easy to deduce from the European Convention that certain articles contain rights which in themselves are clear manifestation of the rule of law, as a rule with a stable content, such as Article 5, Paragraph 1, concerning requirement of a legal basis for the deprivation of liberty, and Article 7 to the Convention, containing the principle well known to all the lawyers of criminal law, nullum crimen nulla poena sine lege. In the latter case, the hybrid dimension, the rule of law can appear in its dimension, having both normative force as a legal principle and as a rule with a fairly stable content. This dimension is to be found in particular in the independence of the judiciary under right to fair trial, as my colleague said, Article 6, Paragraph 1 of the Convention. The independence of the judiciary comprises both de jure and de facto elements under this right to fair trial. With regard to the de jure independence, the case law of the court on the dismissal of judges is particularly important, as can be seen from court judgments in Grand Chamber, and I refer to Baca versus Hungary of 2016 about the rule of law in Hungary, and Denisov versus Ukraine in 2018. All these judgments contain the proposition that the removal of judges, of national judges, is subject to strict scrutiny by the European Court because of the principle of the irrevocability of judges. However, this formal de jure independence undermines the framework of the status and activity of judges laid down by national law, does not itself sufficiently guarantee or protect the independence of the judiciary. What is equally necessary, and perhaps even more crucial, is de facto independence. As the European Court explained in 2013, authorities, as well as on any other state authority, irrespective of its level, to respect and comply with the decision and judgment of the national courts, even if they disagree with them. The state's respect for the authority of the courts is thus a fundamental condition for the confidence of the subject before the courts, and more generally for the rule of law. Finally, this latter condition for the de facto independence of the judiciary was developed in another landmark case of our court, Reyes versus Lithuania, just 3 years before, in which it has been held that public statements by politicians and measures taken by the executive to control judicial proceedings have a direct impact on the impartiality of proceedings before national courts. Thank you for your attention.
Thank you.
I think it is on.
It's open.
Good morning, everyone. It's a pleasure for me to be here, and I'm highly honored to be here. I presently work in the Supreme Court of Nigeria. Nigeria is a federation of 36 states with a federal capital territory and an estimated population of 220 million people. My major role as a justice of the Supreme Court is to review the decisions of the Court of Appeal, decide disputes between the federal government and the state governments and between state governments, and sometimes includes the unenviable task of deciding which among competing politicians won the general election at the state or presidential level. So in Nigeria, we've had a checkered history. The Independence Constitution in 1960, the Republican Constitution in 1963, and the present Fourth Republican Constitution has encoded the UDHR, the Universal Declaration of Human Rights, in the Constitution in Chapter 4. So, and Nigeria is a state party to several international treaties dealing with the enforcement of human rights. And we have domesticated most of these international treaties, and they are part of our domestic law. So basically, Judge Campbell has defined the rule of law. But the rule of law, just say that the rule of law is a political philosophy which postulates that the citizens and institutions within a political entity are not subject to arbitrariness. Nigeria is a democracy. There are three arms of government: the executive, the two houses of legislature at the federal level. There are also three tiers of government: the federal, the state, and local government. The judiciary basically does a balancing act to ensure that the principles of separation of powers are not violated between the competing entities and these competing entities, and that these competing entities do not infringe on the rights of the citizens they govern. So, we all know that courts are the guardians of the law, and particularly of the rule of law. So, the most important duty of the hierarchy of courts in Nigeria, from the customary court, which is the lowest court that deals directly with the people, to the Supreme Court, where I serve, is to ensure that the action of governments and its agencies and the actions of the legislature comply and are not inconsistent with the fundamental human rights provisions of the Constitution. So, what we've done, the law itself has no meaning unless it is enforced. So in Nigeria, the Constitution provides that if anyone believes that his fundamental human rights has been violated, he has the right to go to the federal high court or a state high court to enforce these rights. And there's a fundamental human rights enforcement rules. And the lawyers will use these procedural rules to engage and enforce these rules in the courts. So basically, the courts review executive and administrative actions to entrench fair hearing, the rules against bias, and the rules of natural justice. You know, the rules of all the other batem, you must hear both sides, the rules against being a judge in your own cause and all that. So the courts in Nigeria basically say that the right to fair hearing, being a fundamental constitutional right guaranteed by the Constitution, the breach of it in any form by any administrative panel renders that inquiry or that judgment a nullity. So I'm very proud to say that within the short time I got to the Supreme Court, about 2 and a half years ago, we have expanded the rule relating to public interest litigation. It used to be in the past that we thought that if you didn't have a direct interest in a matter, you were just some interloper, and you had no locus to sue. So recently, in the case of Center for Air Pollution Watch versus NNPC, the Supreme Court held that it would be a lacuna in the system of public law if a pressure group or even a single public-spirited taxpayer were prevented by outdated technical rules of local standard from bringing a matter to the attention of the courts to vindicate the rule of law and get an unlawful conduct stopped. So, and right now it's time for you to tell you how diverse Nigeria is. Nigeria, of course, is perhaps one of the most diverse countries . Geographical, economic status, and we all live together in sometimes tenuous harmony, bound together largely by the rule of law. So the courts foster generally the principles of acceptability of human rights. And in all this mix, the Supreme Court accepts the concepts of our cultural and religious diversity and the need to respect each other's differences, and accepts our individual uniqueness, but has tried over the years to ensure that the enthusiasm of the majority does not infringe on the rights of the individual. And we have refused to invoke the principle of cultural diversity to infringe on human rights provided by the Constitution and international law, or to limit the scope of human rights. So we have like a yardstick, a culture, a religious belief, whatever, in the mix of all this diversity must not be contrary to natural justice, equity, and good conscience. So that is the test. So in case, for example, in a case in some parts of Nigeria, eastern Nigeria, the women are regarded as chattels. So a chattel is to be inherited and cannot inherit. So in a particular case that came up to the Supreme Court, the daughter and the wife of the deceased was prevented from having possessory or even usurpatory title to landed property of the deceased. So the Supreme Court held that it was against natural justice, equity, and good conscience to deprive the daughter and the wife from having access to the land on which they depended for a living. It had always been the attitude of the Supreme Court in the past, because the state law, not the federal law, the state law, even in the will's law of the state, would provide that when a man makes a will, that will must not be contrary to the culture to which he subjected himself. So if he was a Yoruba man whose culture was that the wife could not inherit, even if he made a will to divest or to give property to his wife, that portion of the will will be null and void. So the Supreme Court now held that such practices and such laws at the state level were struck down because they were contrary to natural justice, equity, and good conscience. So, and then the next yardstick used by the Supreme Court is that before we approach the issue of particularly freedom of expression, peaceful assembly, freedom of movement, with the mindset that the constitutional provisions provide that they are conditional. But the law, that any law made to restrict these fundamental rights cannot be struck down if they are reasonably justifiable in a democratic society. So the Supreme Court gets to determine if a set of laws that infringe on the fundamental human rights are reasonably justifiable in a democratic society in the interest of defense, public safety, public order, public morality, or to protect the rights of others. So it depends largely on what the Supreme Court determines is reasonably justifiable in a democratic society. So there are some examples I'll give you, particularly in relation to religious freedom. There was the case of, in the north of the country, where the local government forced some children in that area to attend Islamic schools, some Christian children. The High Court held that it was not justiciable. The Supreme Court held that it was justiciable and that the children could not be forced to go to Islamic schools since they were Christians. Then we have the case of somebody whose eyewitness testimony was refused because he did not swear on either the Quran or the Bible. He just decided to affirm. And the Supreme Court held that he could affirm and not necessarily swear by the Quran or the Bible. And then we have the interesting case of the Jehovah's Witness who sued the family who sued the doctor because he allowed he obeyed the instruction of the patient not to be transfused with blood, and the patient died. So the families reported to the medical council, and the medical council struck off the name of the doctor from the register, and the Supreme Court reinstated the doctor on the basis that the man had a right to choose his way of life. If he did not want to be transfused, he could not be forced to be transfused. Conversely, in similar circumstances, a child of the Jehovah's Witness who had to be saved by being transfused, the doctor got a court order, transfused the baby, and the family took him to court for violating the fundamental rights of the baby. The Supreme Court held, no, by the Child Rights Act, the court is mandated to enforce the right to life of the baby. And in any event, the baby was too young to choose between the religion of its parents or its right to life. So we have so many examples of that. The latest is the wearing of the hijab by the Supreme Court. The Supreme Court held that students could wear the hijab so long as it did not affect their identity in school. Because you could not wear, a man cannot pretend to be a woman and come in to do exams with a false identity and all that. Do I still have time? So basically, the Supreme Court and the courts in Nigeria, because of our long history of military interregnum, we've seen ourselves as these swashbuckling knights in shining armor, protecting human rights in Nigeria, because we had independence in 1960, the coup in 1966, and fortunately the coup leaders left the provisions of the fundamental human rights. So they would arrest, they would harass, and then the lawyers would go to court, and the courts would rise to the occasion and make sure that the human rights, the fundamental human rights of citizens were enforced. So the soldiers, there was, in 1979, there was a civilian regime again. 4 years later, the army came back in 1984, January. So we didn't have democracy again until 1999. So yesterday, October 1st, is like our longest, we celebrated, I think, 23 years of unbroken democracy in Nigeria. Please give us a round of applause. So we've tried. The courts have, tried because the soldiers were kind enough. We must give them that. Or because they were sensitive to the world politics, they tried not to remove the fundamental human rights provisions from the abrogated sections of the Constitution. Because they come in, they will say they've abrogated this section, that section of the Constitution. So they would leave the provisions relating to fundamental human rights, which they didn't touch. So I've been winked at several times. So thank you very much for listening to me.
Good morning. Can you hear me loud and clear? All right, fine. In the Philippines, we usually start by saying, Mabuhay. Mabuhay, long live, and may God be praised. Now let me start by reiterating what we always say about the rule of law. The rule of law essentially states that nobody is above the law. That's the usual statement that we come across. And this means, of course, that the law treats everybody equally and impartially. Laws are created and enforced in such a way that even the highest government official is not above the law. In our country, Philippines, we try our very best to promote. We endeavor, we try to maintain the rule of law. Otherwise, if the rule of law is not maintained, then the rule of the mob takes over. And it does happen in many parts of the world. So do we allow the rule of the mob to set in? Well, in our country, again, the rule of law is an essential aspect of modern democracies. There are 4 universal principles that define the rule of law. And what are these? Accountability, just law, the government that is open, accessible, and impartial. On the other hand, the strengths and the weaknesses of the rule of law are put to test in instances such as, you probably would know, tax evasion, environmental protection, intellectual property, traffic laws, international law, and religious freedom. Let me just take the case of religious freedom for purposes of our symposium. Now, how does the rule of law and judicial independence impact on the protection of human rights, including religious freedom? The Philippines proudly boast to be the only country in Asia in which Christianity is the national religion. More than 86% of the population is Roman Catholic, 6% belong to various nationalized Christian groups, and another 2% belong to well over 100 Protestant denominations. The dominance of the Roman Catholic population must be the result of the Spanish Catholic reign in the Philippines for more than 300 years. The 1987 Philippine Constitution has provided for the separation of church and state. And further, the Constitution has provided that no state religion shall be established, and nor shall the freedom of religion be prohibited. So there is, in fact, freedom of religion. Now, the charity works of the Catholic parishes in our country, as well as public schools, contributed to the health and well-being of our less fortunate families. Now, briefly, let me now go to judicial independence and its relation to the rule of law. Judicial independence and the rule of law are closely intertwined concepts that mutually reinforce each other in preserving democratic values and principles. Both are essential for the functioning democracy and the protection of human rights. Judicial independence per se refers to the ability of judges, members of the judiciary, as well as the courts, to make impartial and authoritative decisions based on the rule of law. It ensures that the judiciary is unswayed by external pressures, so it must be. It plays a crucial role in maintaining the balance of power between the three branches of government, the legislative, executive, and judicial branches of government, while safeguarding citizens' rights and liberties. There are indeed three branches of government in our country, but while independent of each other, these three branches are likewise interdependent. Now, the rule of law likewise establishes a framework of a clear, transparent, and predictable rules of court, legal rules that enable judges to fairly and consistently apply the law. I refer to the rules of court promulgated by the Supreme Court. And the rules of court are adopted by all of our courts. And the rules of court are really intended to expedite the resolution of all cases, civil, criminal, administrative, and so forth, and so on. By adhering to this framework, our judges contribute to the maintenance of judicial independence, as this ensures their actions and decisions remain focused on the law rather than external factors. Now, finally, I'm entitled to 5 minutes, right?
Yeah, you're good.
Yeah. It's barely 3 minutes. In my judicial career, let me share a little bit. In my progressive judicial career of 42 years, I have used the following safeguards to maintain judicial independence. Number one, confidentiality documents of legal staff in all courts strictly followed from the highest to the lowest member of the staff. So we maintain confidentiality of our records. Second, consistent implementation of the rule of law by establishing a good reputation as a judge who is impartial in his decision. Third, avoidance of occasions to be influenced by not entertaining people who are involved in a given case. Limit, this is addressed to the judges, limit socialization that will expose you to temptation or people you cannot refuse because somehow at one time or the other, he or she has helped you to be promoted. Fourth, be cautious of being misquoted by media people. One way not to be misquoted is to give a written statement rather than an interview, especially ambush interviews, which are done hurriedly. Five, be careful also to entertain favors, course through your family members or closest friends you cannot refuse. Educate and warn your family members and friends on how to avoid being used to gain favor in decision-making or leakage of documents, premature release of decisions, conniving with your staff in getting advanced or confidential information, and many others. Number 6, create preventive measures from all possibilities of undue influence in your judgments and actions. One way is not to delay decision of cases, but rather train your staff, your legal staff at that, to be swift in doing their research thoroughly, writing their drafts with utmost accuracy, and making sure that the timetable given to each case is followed. Then finally, how does our courts continue to exist, maintaining the rule of law and preserving independence? Our courts, from the Supreme Court down to the lowest municipal trial court, have always been guided by the new Code of Judicial Conduct for the Philippine judiciary. I am sure the judges here in the United States are also aware of the Code of Judicial Conduct, the latest of which was one that was approved by the justices, chief justices in Bangalore of The Hague on November 2002. And this judicial conduct has really guided the judges. Then we also have, just last April, the Supreme Court has adopted a revised Code of Professional Responsibility for lawyers. And again, this is to guide our lawyers in our country. Then, I have of late been introducing to the Philippine Judicial Academy, where I teach and of which I am a member. The Philippine Judicial Academy is the judicial arm, judicial education arm of the Supreme Court. And we educate, we train, we give continuing legal education and judicial education to our judges. And so this for our is very important, no? Maintaining judicial education, because in a way, this reminds us of our judicial conduct. And then, also, I have tried to introduce what we call, in our grade school, good manners and right conduct. Agree? This is something that we have overlooked. And this is something that we need to go back. This is, best conduct. Even for judges and lawyers, we really have to be reminded of how to behave in our official capacity and in our private capacity. Values formation is important. And I do hope that we all adopt this and reach out really to all the judges and justices. And also, let me just stress the fact that we are all, my brethren, my fellow lawyers and judges, we are all bound by our lawyer's oath. Are we? I think the United States have the same, we have the same lawyer's oath, right? And just recently, the Supreme Court, in April of 2023, revised our lawyer's oath, but substantially maintaining the same old lawyer's oath that we have had for many years. And we do hope that our lawyer's oath should not be taken lightly. You know, we should always be reminded of what the lawyer's oath is. Let me ask you a question. Father, is the lawyer's oath a prayer? I've asked this in several gatherings, and they found it difficult to answer. Is the lawyer's oath, is the code of medicine, is the code of law of engineers, architects, they have all their oath of office. Is this a prayer? Now, this is something that has helped me, guided me all these years. The lawyer's oath. Is the lawyer's oath a prayer? Yes, indeed. You look at the last part of the lawyer's oath. It says, "So help me God." Whatever religion you are in, you just have to seek the help of God, right? So that is a prayer. So help me God. And to be able to be protected from wrongdoings, corruption, your honor has always been shielded by God, because I follow the lawyer's oath, which essentially seek the help of our God. Without God, or with God, everything is possible. We can decide all cases intelligently and religiously. And my shield all throughout my court duties has always been our Lord God, together with, of course, the Holy Spirit. All right, thank you very much, and more will be coming later.
Good morning. It's a pleasure to be here. I take this opportunity and would like to thank the symposium organizers for their kind invitation and warm hospitality. We all know that the idea of constitutional justice is based on the assumption that our rights and freedoms are not guaranteed when rulers have absolute or unchecked powers. The Gilgamesh epic, which was written about 4,000 years ago, tells us the story of how the gods created Enkidu to check and control King Gilgamesh, who was oppressing the people of Uruk, the first ever known city in today's modern Iraq in the world. However, the project of ending the tyranny of the King Gilgamesh ended up in failure when Enkidu became the king's best friend and they began to oppress people together. So in today's world, 4,000 years later on, we still seek to resolve what's called the Gilgamesh problem. That is how to control the political authority. In a number of measures that attempt to quantify levels of democracy, freedom, and the rule of law, the retreat in these areas is readily visible in many parts of the world. For example, according to a widely used measure by political scientists, the number of liberal democracies went down from 44 in 2009 to 32 in 2012. Similarly, last year's Freedom House report observed that for the 16th time in a row, the worldwide level of freedom fell and civil and political rights experienced a number of setbacks in more than 60 countries all over the world. So let me give a very brief summary of the Turkish Constitutional Court's experience against this background. Turkey, which is the official name of the country, so we don't use Turkey anymore, so we don't use the bird's name. Officially, it's the Republic of Turkey. So Turkey has a long history of constitutionalism, dating back to the first Ottoman Constitution of 1862, when some of the absolute powers of the Sultan were restricted. The Turkish Constitutional Court was set up in 1962 with the jurisdiction of centralized constitutional review. It has the power to conduct constitutional review of laws, presidential decrees, adjudicate individual applications, and decide the solution of political parties if their activities contravene the eternal and unamendable constitutional principles. Currently, the individual application remedy accounts for the vast majority of the court's docket. The subject matter of this individual application system is confined to rights and freedoms that are commonly protected by the European Convention on Human Rights and the Turkish Constitution. Since September 2012, when the system was introduced, the Constitutional Court has received about 500,000 individual applications since then. And currently, we have more than 100,000 individual petitions are pending. The court has so far delivered around 70,000 violation judgments, corresponding to around 18% of all concluded individual petitions. Among the violation decisions, the right to fair trial, including the excessive length of proceedings, constitute the most violated rights. Following this right, freedom of expression, the right to property, freedom of assembly, and the right to respect for private and family life are among the fundamental rights and freedoms with the highest rates of infringements by public authorities. The high rate of inadmissibility decisions results mainly from the fact that many applicants confuse the individual application system with appeal review. Since it's not vested with the power to quash the judgment of the lower court. The Turkish court has found violations regarding many issues, including but not limited to wrongful detention, disproportionate and excessive use of force by security officials, degrading treatment, married women's use of their maiden surname, blocking access to internet, headscarf ban at public institutions and universities, election of religious leaders in minority religion communities, freedom of communication of inmates, suspension of strikes, and the right to unionize. The court's case law has to a large extent set out the standards to protect constitutional rights in conformity with the jurisprudence of the European Court of Human Rights. In terms of freedom of religion, in the past, the court had a policy of what might be called militant secularism. For example, the court didn't allow female university students to wear hijab at their university premises, or no female civil servant is allowed to wear hijab when they work in the public service. So recently, we have adopted a more, what might be called a liberal understanding of secularism, so that people can enjoy their freedom of religion in the public space. In the past, the court had an understanding of militant secularism, which denied the enjoying of the freedom of religion in the public domain. So you can enjoy your freedom of religion in the places of worship or at your homes, but not in the public space. Currently, we have a number of pending applications related to confiscation of church properties by the public authorities. In Turkey, there are officially recognized 3 religious minorities: Greek Orthodox Church, Armenian Apostolic Church, and Chief Rabbinate of Jewish people. But we have also recently some problems emanating from the application of not unofficially not recognized Protestant church. For example, we have a pending application about the establishment of temple by Jehovah's Witnesses. We haven't made our decision yet. In addition to that, we have 2 pending cases related to conscientious objection. These 2 cases, one of them emanates from a Jehovah's Witnesses, and the other one claims to be a Muslim conscientious objector, which is a very interesting case. I believe it would be the first ever case, Muslim conscientious objection case in the world, to the best of my knowledge. Currently, the most important problem we face is the rising workload. More than annually 100,000 individual applications, we find it very difficult to conclude them in time. So in a way, the court creates a kind of problem related to the right to fair trial, excessive length of proceedings. So, but it's not our fault, to be honest with you, because it's not just our responsibility to protect human rights in the country. We have different parts of judiciary, the executive, the legislature. They all have the responsibility to protect human rights of the citizens. And also another problem, you know, Turkey hosts more than 4 million Syrian refugees and many illegal immigrants from various African and Asian countries. And their deportation cases takes a lot of time as well. So we find it really difficult to deal with all these issues. I mean, the court is composed of 15 judges. We have more than 100 law clerks, which helps us in preparing the cases. But again, this is too much. I mean, as far as I know, the constitutional complaint system usually takes about 5,000 or 6,000 applications per year. I know the German system and the Spanish system, in both countries, they receive around 6,000 individual applications per year, and they find it, they say it's too much. So compared to us, it's nothing. But again, it's not because we don't work. I think other branches of the government have large responsibility for this state of affairs. Unless public authorities and bodies, including the judiciary, observe human rights in their decisions, the Turkish Constitutional Court cannot bear the burden of addressing human rights problems alone. An effective and functional constitutional judiciary depends on the fulfillment of external and internal conditions. Both are related to the institutional quality of the constitutional order. Constitutional courts can indeed contribute to democracy and the protection of the rule of law if the institutional circumstances support their work. Thank you very much.
Thank you for those interesting and informative discussions of what you're seeing from your various countries. I wish we had another hour to pursue this discussion, but we don't, and I have pledged as the moderator that we will be done by 10:30, so we are almost at the end of our time. This discussion will continue in the judicial breakout, and I've noticed my colleagues making notes, and we're going to continue having this discussion in those breakouts, but this has been very helpful. I appreciate Justice Harutyunyan explaining the role of the European Court of Human Rights and how it's in the very unique position of trying to ensure that the 46 countries below it apply human rights and allows them to address human rights first, but seeks to ensure the independence of their courts and the fairness of their procedures. I appreciate Judge Ktisakis pointing out that the convention applied by the European Court of Human Rights, like the Universal Declaration, has the rule of law mentioned in its preamble, and his discussion of how the process countries use to remove judges can affect the independence of the courts, and the public statements that government officials make can affect courts, and we are seeing that in our country as well. I appreciate Justice Ogunwumiju pointing out that Chapter 4 of their Constitution reflects the values of the Universal Declaration of Human Rights, that they apply principles of equity and good conscience and are now celebrating 23 years of democracy, which is wonderful. Justice Reyes helped us understand that the opposite of the rule of law is the rule of the mob. I took careful notes on his points for judicial independence that are helpful to all judges, and really appreciate his emphasis on good manners. We can use that lesson throughout the world and in our own country. And Justice Yildirim helped us understand this is a very old issue, 4,000 years old. He pointed out that Freedom House has found that democracies are in decline, just like the World Justice Project has found that the rule of law is in decline, but also that all branches of government have a responsibility to protect human rights, not the courts. So my hope in my closing comments is that as we go back to our countries, we will keep in mind that the rule of law and the independence of courts are indispensable but perishable. There is no guarantee that they continue. Whether they continue is dependent upon what we as citizens do to ensure that they continue. And that's critical to our role of protecting human rights and religious freedom.